Hello and a very warm welcome to you. This is the Courthouse, our law class 101. Yes, we get to learn the law in plain, simple and entertaining language. We have something very interesting for you this week. After this break, we'll let you know more. Stay with us.
From Lagos
to London, from Johannesburg
for several years, our economy
to the United States,
identifying houses of worship.
We have all the world covered for you, no matter where you are.
Love with News is at the heart of it all.
I have experience.
We bring you our perspectives of stories behind the story.
The signs given to us for the entry of these things are before us.
Join us.
Join us.
Join us on this station.
You're welcome back. Well, if you just joined us, this is the Courthouse, and this week on the show, we are going to be taking a look at the amended Companies and Allied Matters Act, Cama. I know on the headlines on major newspapers, we've been hearing about Cama, the implications of the amendment and how it affects non-governmental organizations, churches, and the like. And as usual, I'll be joined by a seasoned legal practitioner who will be giving us his insights into this new amendment and what it really means. On the show, joining us now is Tony Orunkoya, a senior legal practitioner based in Nigeria and majorly a human rights activist and a doctor of law. You're welcome to the show, sir.
Thank you very much. Thank you very much.
Okay, so just like I mentioned earlier, I've been hearing about Cama, we've been hearing the Christian Association of Nigeria, some other non-governmental organizations talking about the implications of this new amended Companies and Allied Matters Act, Cama, and they've been saying that there's so much negativity about the new Cama. Just give us a basic insight or a background into Cama, what it stands for, and some of the amendments that we'll be interested in.
Yes, the Cama simply means the Company and Allied Matters Act, a law made by the National Assembly, an act of the National Assembly, so to speak, that regulates the registration of companies. It also regulates the registration of incorporated trustees under Part C. Under Part A of Cama, we have incorporation of companies. Under Part B, we have registration of business enterprises, small business units that are not as big as companies. Then under Part C, we have incorporated trustees like associations, like churches, like civil rights groups. These are registered under Part C of Cama. You see, the issue of regulation of activities of companies or incorporated trustees or business enterprises is not something of today. The Cama has been existing, and it is a law to regulate the affairs of these various artificial personalities, because they are not human entity. The artificial personalities, so there is need to regulate their activities. These are what their objects, what they claim they do, like a company that is into production or certain goods. There is a law to regulate how the board should meet, the rights, powers, and limitation of the shareholders, the rights and powers of the directors, and how you can subscribe for shares of these companies. Then when you now come to Part B, that talk of business enterprises, what applies to Part A also applies to Part B, which is strictly business. But when you come to Part C of Cama, you are talking of non-profit making ventures, non-profit making organization. And it is deemed that churches are not really a profit making venture, that churches and mosques the essence is to build spiritual upliftment of their members. And the associations too is to also provide for the welfare of their members, and welfare of persons with common objective, with common goals, and how to pursue this common goal. But there is no way these associations can operate within the entity called Nigeria, within a nation, without being regulated by law.
You know, a lot of civil society organizations have also raised concerns about the fact that the particular section in question, Section 839 of the new Cama, seems to be interfering with the operations of these organizations, non-governmental organizations, of course, churches and the likes. And they seem to believe that it is a way of sneaking in the NGO bill that was tried, that several times there were attempts to pass the NGO bill and the bill died on arrival. People believe that this is another attempt to stifle opposition, to stifle freedom of association, freedom of religion and the like. What is your take on that?
To some extent, that is correct. But I disagree to the extent that, you know, for every 12, there is always a Judas. Some of these associations are operating according to the rules of Cama before now. Some of them have their own internal constitution and they are operating according to the internal constitution. But in a situation where an association collects money from international bodies, get grants, and these grants are meant for a particular purpose, and they are not applied, and the government cannot really come in to unveil those behind the acts. Like under Part A, if a director is acting outside his powers as provided in Cama, there is what is called lifting the veil of incorporation, so that the directors can be pursued under the law and prosecuted. But we don't have such situation under Part C. And because we don't have such situation under Part C, trustees of incorporated trustees most times act beyond their powers, especially those that are getting grants from international donors, thereby putting the image of the country, you know, in bad repute. So these are some of the things the government want to cross-check.
Okay, thank you so much for that. Now, looking at this issue of Section 839 of the amended Cama, a lot of non-governmental organizations are really raising the alarm that this is more than an ordinary interference in the runnings of Christian associations, in the runnings of civil society organizations. Tell us a bit more about Section 839 and what it really stands for.
Yes, the Section 839 of the amended Cama simply empowers the government to look deeply into the affairs of incorporated trustees more than before. The government can actually evaluate, appraise the activities of incorporated trustees, that is associations registered under Part C, if with a view to know if such associations are acting against extant laws. Trustees of incorporated trustees can be prosecuted by government where they are found wanting. Incorporated trustees can be taken over by government if there is a breach of the extant law. The government can appoint managers to look into the affairs of incorporated trustees and administer incorporated trustees for a period of time. However, the challenges that particular provision is having is that the Corporate Affairs Commission, SOMOTU, can act without recourse to court in delving into the affairs of the corporate trustees. That is where the challenge is. So most groups who are against Section 839 are not saying, no, don't look into our affairs. But if you must look into our affairs, let us follow the due process of law. This association was formed by persons of like mind who have common objectives, common goals to pursue. And if they come together to pursue their common goal, you cannot just jump into the affairs as a regulatory body to say, okay, I found you one thing that you are not going by the rules, and as such, I've appointed administrators or managers to take over the affairs of your association. That in itself is a breach of the provision of the Constitution. Without passing due process of law, Corporate Affairs Commission cannot appoint administrators, appoint managers to manage the affairs of these associations. That is just the problem. So I think Section 839 gives more power to Corporate Affairs Commission, and that is a breach of right to freedom of association. The Corporate Affairs Commission is not part of the association. Officials of Corporate Affairs Commission is not part of the association. And if there is any allegation against any corporate trustee by way of petition with respect to their affairs, then that petition should be looked into in a court of law. The petitioners can join Corporate Affairs Commission, suit the corporate trustees to say the trustees of this association are not working in accordance with the constitution of this association. Because for every corporate trustee, there is a constitution. It's not just about freedom of association alone. It's also about right to fair hearing. If the allegation about mismanagement, let us take the issue of mismanagement, because one of the major reasons why those in support of Section 839 is welcoming, why they are welcoming that provision, is because they are of the view that some associations get grants
from international communities.
Donors.
Yes.
And these grants they get are not applied for the purpose for which the grant is given. One. Another reason is that most incorporated trustees, after incorporation, do not go by their objects. Incorporated trustees are incorporated, but did not go by their object for which they are incorporated. Good. We are saying that these associations can be regulated. Yes, their object or their activities can be checked, but for to check them, due process of law must be followed. You don't solve a problem by creating another problem. Cama and the Corporate Affairs Commission is not part of the association. And the Constitution provides for freedom of association, equally provides for fair hearing. So if this association are in breach of any extant law, Corporate Affairs Commission should approach the courts to say the trustees of this association are in breach of XYZ extant law, and as such, we want to appoint administrators, managers to manage the affairs of this association. Like in companies, Corporate Affairs Commission do not just appoint a receiver to manage the affairs of companies. If companies are in breach of their powers, or there is any breach of any extant law, and there is need to take over a company, then CAC goes to court, or any of the shareholders, or any agreement of the public, we go to court for appointment of a receiver manager to manage the affairs of the company. You know, these issues, they are not new. They are not new. They are not new. But the problem we are having with Section 839 is that CAC can Somotu appoint a manager, appoint an administrator to oversee the affairs of this association. That's why the issue.
Thank you for helping us understanding that provision, Section 839 of the amended Companies and Allied Matters Act, Cama. And that's basically, like you said, it seems to stifle the freedom of expression and association of most citizens and through the associations that they created for themselves. We'll want to take a listen to our report. Our report is on an overview, a highlight of Section 839 and other implications of the new Cama. We'll be right back. The new Companies and Allied Matters Act, Cama, is celebrated as a welcome innovation to the Nigerian corporate business world as it results in an overall increase in the ease of doing business. The positive changes introduced by the amendments include in respect of the incorporation of companies, limited liability partnerships, limited partnerships registration of business names, together with the incorporation of trustees of certain communities, bodies, associations, and other related matters. However, as laudable as the new Cama seem to be, there are certain provisions that offend against the constitutionally guaranteed rights of freedom of association, expression, and fair hearing. Of particular concern is Section 839, subsection 1 and 2 of the new law that provides for the Registrar General of the Corporate Affairs Commission and a supervising minister to strictly regulate religious bodies and non-governmental organizations. Civil societies and religious bodies have described the controversial section as needless meddlesomeness in their operations and vowed to resist it. The law also wields power to suspend the trustees of not-for-profit organizations and appoint an interim manager to coordinate its affairs where it reasonably believes that there had been any misconduct or mismanagement, or where the affairs of the association are being run fraudulently, or where it is necessary or desirable for the purpose of public interest. The question remains, what constitutes public interest? Even though some jurists believe that Section 839 is a regular provision which should not raise any dust, there is a grave danger in allowing a government with an antecedent of wanton disregard of human rights to be left unchecked with such wide and sweeping powers given to a body such as the Corporate Affairs Commission to monitor and supervise activities of associations that they know nothing about. You're welcome back. This is still the Courthouse, and we've been talking about the amended Cama, the Companies and Allied Matters Act, and what implications it has for non-governmental organizations and churches alike. And we've been speaking with Tony Orunkoya, a doctor of laws, and he's been talking about the fact that governments would be interfering with the rights of the members of this association if they are allowed to go into the activities through the Corporate Affairs Commission, CAC, by appointing managers to oversee the affairs of an organization. It basically means that you are taking over the affairs of that organization and you're going to stifle opposition, you're going to stifle freedom, dissenting voices and things like that. We still have Tony Orunkoya, who will be giving us some more thoughts on what rights these trustees, these members of the association that the government will be interfering with, what rights do they now have under the new Cama?
Nothing has really changed in the recess apart from the powers now given to Corporate Affairs Commission to delve into the affairs of this association. However, I will want to say that most times we give room to government intervention into our affairs, directing the affairs of most let me call it churches. When I say direct the affairs, they see to the operation of these churches. We have a lot of churches here and there, and they seem not to be under any regulation. And even the very big churches too, they have issues when it comes to transition of leadership from time to time. The same thing with the Muslim associations too. They have a lot of skirmishes here and there. So if the Christian association and other religious body who are now against Section 839 are be living up to expectation, will not be having the present crisis we are now having, where the government have to come in and empower Corporate Affairs Commission to look into their affairs. Most times you see Cama talking about politics, but the body of Christ, which they represent, they seem to be far away from it. They are not really interested in trying to find out these churches, how the affairs of these churches is being regulated. And most members of the incorporated trustees, you see a husband and wife will come up to form an association, to form up a church, and members are gathered as to fellowship together as a body of Christ in a church, and the members of the church don't even have a say in the financial issues of the church, and it gives a concern to some of us. We believe that there should be balance in the right of those who have come to set up these trustees and their followers, those who labor to ensure the success of these incorporated trustees. So with the present provision of Section 839, an aggrieved member of the church who has been contributing towards the development of the church for a long while, and who also feel that the affairs of the church is not being handled the way it should be handled, can petition Corporate Affairs Commission for Corporate Affairs Commission to delve into the affairs of the church, or to delve into the affairs of the association. We have a lot of associations, not just churches. It's not just about Christianity or Islam. So there are a lot of associations that are affected by Section 839. So the members of these churches, members of the association, can by way of petition to Corporate Affairs Commission to say, please come and look into the financial statement of this association. We feel that the funds we are contributing is not being applied the way it should be applied. But the issue we are having with that Section 839 is the fact that so much Cama can act without recourse to court on that, and that affects freedom of expression.
These associations, if they decide to go to court, they want to find out what the position of the law is, or if they can actually challenge that Section 839. Is there any chance that they would succeed in court?
Well, I appreciate your question, but I don't want to delve into issue of whether there is any chance. In law, EB Jews, EB remedy. Where there is a wrong, there is a remedy. We've pointed out some defects, so to speak, in Section 839, because that particular section, if critically looked at, offends some provisions of the Constitution with respect to freedom of expression, freedom of association, and the issue of right to fair hearing. So I will not want to say categorically whether they are going to succeed in court, because I'm going to court myself. My association is going to court to test the propriety of Section 839. So I cannot sit here to say I'm going to win when I go to court. But I know I've seen defects in that section, and I want to go and test the law. Apart from Christian Association of Nigeria, my association wants to go and test the law, want to go to court to test the provision of that section. These are the provisions of the Constitution that I mentioned. In a situation where a manager, an administrator is appointed to come and manage affairs of my association because of a petition, and you did not give me the opportunity, the privilege of defending myself without a court order, and you not take up my association, when you don't understand the dynamics of the association. So there are issues of law that can be tested in court. If you ask me, there are issues of law that can be tested in court, I'll tell you yes, there are issues of law that can be tested. One can go to court to ask the court to determine whether, by virtue of the extant provision of the Constitution, which grant freedom of expression, which grant right to fair hearing, whether the Corporate Affairs Commission can somehow, without recourse to courts, take over the management of affairs of an association.
Thank you so much. Thank you so much. Now, you've been mentioning some Latin maxim. You've used suo motu several times. Can we get your meaning? What is the meaning of suo motu?
Yes, what I'm trying to say is that that particular session empowers Corporate Affairs Commission, that is section 839, empowers Corporate Affairs Commission to take over the management of incorporated trustees by fiat on its own without a court order.
On its own. Thank you so much. On that note, we'll let you go. That is Tony Orunkaya talking about the effect of section 839 of the amended Cama, and of course he gave us the meaning of that Latin maxim suo motu. Suo motu means by itself, someone acting on its own or on our own. We have some more Latin maxims in our bar book segment. Stay with us. Well, that's what you can take this week on the Courthouse. We talked about the new Companies and Allied Matters Act, and we looked specifically at the provisions of Section 839 of the amended Cama and the fact that it will have grave implications on freedom of expression and freedom of association of non-governmental organizations. And we know that non-governmental organizations are registered under Part C of the Companies and Allied Matters Act, and that includes churches. And of particular interest to us on the Courthouse is the fact that the church would be affected, would be investigated, and undue interference by the government would be meted out on the church if that section is not checked. And our legal practitioner did advise us that we can actually go to the courts and test the law and test the provisions of the new Cama and see if it will stand the test of time. That is the much you can take. Indeed, you can join our conversation by using our hashtag Courthouse, hashtag Loverplus, and you can also visit our website on www.loverplus.tv. We'd like you to send questions to our email info@loverplus.org. You can also send comments or questions to the number that I'll be showing on your screen now. I'm Olomu-Agbodo. Don't just get mad, go get a lawyer. Bye for now.